to another episode of Unions Organized and Resilient. My name is Michelle Keller from District Council 37, retiree and voluntary member organizer. Thank you for joining us today. Today, we will enter the second part of our discussion. And remember, the title was Renewing Our Union Vows, Restating Our Purpose. We will cover union functioning. So let's get started. Union operation, our union. What are the members? They are the heart and soul of our union. What about delegates, or otherwise known as stewards? They are the eyes and ears of our union. District Council 37, along with its so many locals, they're the body of our organization. These delegates, frontline and essential, are worker members. They know what's happening on the shop floor, worker spaces that they move around in every day. They let us know about how our rights are being violated. Where's that rally? Where do we find our services and our resources? The delegate and or steward need not be an expert in what's going on or about the union in general, but they must be aware of the appropriate action or safeguard or what safeguards workers' rights. So who are some of these collective union organizations? The AFL-CIO, often called the American Federation of Labor, Congress of Industrial Organization. Our global agenda. ASME, our national agenda. The New York City's Central Labor Council of Workers. Organized and organized matters driven by organizing drives and assisting us with the battle against the bosses. DC 37, home and local, is what guides the locals that are in our very union. Unions combining all efforts. Internal rights of our union. We know about what? The Bill of Rights. The Bill of Rights are for all of our member workers. They guarantee that all union members have the right to campaign and then nominate candidates for office, to attend and participate and organize in our union meetings. The union constitution and its bylaws that speak to the union's rights in our local, to balance the needs and the expectations of various groups of employees in the union. The union will function more effectively to advocate and cover our members. We stay on top of the aligning issues that might be affecting us as an organization. What about our economy, our healthcare, and social justice? How are the bosses operating? We conduct member surveys to determine our top priorities and directions. Those face-to-face sessions that we have with the members, and we assist in the research. Management and labor are legally required to bargain in good faith, to meet reasonable and timely goals around places and times that they will sit down and negotiate. And they must be reasonably flexible in modifying their positions. Tentative agreements are completed only after the word is sent out to the members to ratify the actual vote. Okay, let's talk about workplace rights. Collective bargaining agreements, everybody knows about that, otherwise known as our contract. Laws and regulations, federal, state, local laws. What do they cover? Our wages, our hours, our health and safety, and discrimination laws. The employer and the bosses write what? Handbooks and our rules and regulations. unwritten laws, otherwise known as past practice actions. Anybody ever heard of the NLRA, standing for the National Labor Relations Board, or the National Labor Relations Act? Listen to its quote about workers' rights. Employees shall have the right to self-organize, form or join, assist in labor unions, to bargain collectively through their representatives of their own choosing, and to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or the protection, and also shall have the right to refrain from any and all such activities. A lot of words, but clearly the rules by which we work on now. Let's talk a little now about unfair labor practices. Those were the fair ones. That quote stipulates, what are unfair labor practices? Statements or actions that interfere or restrain us or coerce us from doing our union activity. What is called a company union, where the employer controls the union. Discrimination against employees who engage in union activities or who decline to do so. A retaliation against individuals who file an unfair labor practice or charges. The refusal to engage in good faith practices when bargaining with the union. Health and safety, OSHA, our Federal Occupational Safety and Health Administration. Now, most workers have sufficient right to a safe and healthy environment. I say some because this is one of the benefits of having a union. We get a workplace inspection. We can call for that. We can request work resources and data from the employer's bosses. Did we know that? Workplace injuries, health and safety conditions. And the Environmental Protection Agency can also provide necessary protections. Pension and health care are federal laws. Immigration laws, hiring of undocumented workers, our workers' compensation, state, and the federal government. These are all laws that come in and out of the necessary work or protections of workers, be they union or be they non-union. Let me talk quickly about the Weingarten right. The Weingarten right is very important for each and every member to be aware of it. What does it ask? What does it stipulate? One, that a meeting that's called upon you from a supervisor speaks to an investigation. Two, that you reasonably believe that this disciplinary action may result. And then finally, that you make a request for representation. Let me go over that again. Someone calls you, usually a supervisor or somewhere in the line of management, and says, there's an investigation, we need to talk to you. You need to ask the question, will this involve disciplinary or some disciplinary means on my part? You need to ask that question. If the supervisor or the management thereon says yes, you reserve the right of representation right away. Now, once you get in there, management can decide not to have the meeting. They can decide to wait for the particular representative to have that meeting, or that meeting can disappear. But it is your responsibility to make sure that happens. Again, it's called your Weingarten right. Other laws that involve us as workers. Wages and hours. I'm sure some of you on your paycheck or in discussion with your human resources, you've heard about FALSA, FLSA, standing for Fair Labor Standards Act. It's a federal law. It sets the minimum wage and standards for hours of work and overtime pay at a national level. Discrimination. These are a variety of statutes that outlaw a number of different kinds of discrimination against both job applicants and your current employees. It's a means of challenging discrimination based on the factors of race, ethnicity, age, religion, sex, including harassment, your sexual orientation, and gender identity or mental status, veteran status, physical disabilities, including pregnancy, the family and medical leave, developed back in 1993, otherwise called the Family Medical Leave Act. Most workers, again, the difference between being a union and non-union, are legally entitled to take an unpaid leave because of any of the following events: birth, the care or adoption of a child, foster care of a child, and the care of immediately family member with a serious health condition, the employee's health care. And this is the key, to be able to return to the job with an equivalent position. Next speaker, Anna Berry. She'll talk a little bit about grievances.
What is a grievance? An official statement of a protest or complaint on something believed to be wrong or unfair in contract, law, or regulation. A grievance is the last course of resolution, not the first. And we have to remember, not every complaint is a grievance. There are 5 steps to handling a grievance: identification, documentation, preparation, and presentation. In identification, we have to figure out, did management violate any of the following: contract, work rules or regulation policies, or health and safety, or past practice? Investigation, gathering information, have a clear conversation with the employees, which includes the 5 W's. Who was involved? What happened? Where did it happen? When did it happen? Why is this a grievance? In documentation, collected evidence that will support your grievance. In preparation, the outcome of your grievance depends on how well you prepare ahead of time. Review all of your evidence, distinguish between allegations and opinions, get the facts. In preparation, before meeting with management, prepare an outline for your case. It helps to practice your verbal presentation before you make it. And finally, it is important to know the grievance procedure time limits. If the union fails to file or appeal a grievance within the specified time limits, it is grounds for the grievance to be dismissed. If more time is needed in preparation of a grievance by either side or to ensure the members' availability, it must be mutually agreed upon by both parties, management and labor. In many grievances, the final step is arbitration. An arbitrator is selected jointly by labor and management from outside groups such as the American Arbitration Association and the Federal Mediation. An arbitrator reviews and listens to both parties and makes a decision that may be binding or non-binding. Speaker is Liz Eastman.
Today, I'm going to talk about the duty of fair representation. What is fair representation? Essentially, it means that the union has a duty to represent all members equitably and without prejudice. If the union fails to properly represent the member can sue the union in court or in a case before the National Labor Relations Board. A critical aspect of the duty of fair representation is that the union purposely did not represent the member. If something happens, it's a mistake. Most times the court will not take the case and the union will not be found guilty. Same with the National Labor Relations Board. However, if a union decides just because they don't like someone because of their hair or because they've been anti-union or whatever, and they fail to properly represent them in a grievance or disciplinary, they can be sued. That is the duty of fair representation. What does it mean to be a union member? Being a union member means having one's job protection, workplace safety, and rights, and representation at disciplinaries and grievance matters. The collective bargaining agreement that covers all workers on the shop floor makes the union the sole representative of all workers, whether they're union or not. Thus, health benefits and dental benefits and stuff like that, all workers get, whether you're a union member or not. But the union members specifically get other benefits. Those other benefits are what I've talked about. Representation. The union does not have to represent someone who is not a union member. Also, education classes, help with different union ASPE perks. One of the challenges of the Janus decision, which gives union members the right to opt out of the union if they choose, is the fact that the union can deny non-members the benefit of representation, but the union cannot deny members access to the other benefits that the union negotiates and pays for, such as dental benefits and prescription benefits. That's because the union has agreed to these as per the collective bargaining agreement. Is it beneficial to be a union member? Yes. The union is much more than what you can get from the union. It's about strength in numbers. It's about how the collective voice of workers can improve working conditions and benefits the shop for all workers and gain respect from management.
Thank you for giving us the time to speak to you today. I'm hoping that some of what the sisters have shared with you today will stay with you. And if you need more information, you certainly have your delegate, your chapter president, your local president, and you have our biggest union, District Council 37. Thank you so much. Bye-bye.